Landmark ruling sets precedent for criminal justice reform establishing equality for bail access nationwide. The Illinois Supreme Court has declared the elimination of cash bail constitutional, affirming the state's commitment to reforming its criminal justice system. The ruling, which upholds part of the SAFE-T Act, will lead to the complete abolishment of cash bail across the state, making Illinois the first in the nation to take this bold step towards ensuring equal justice for all. The new system is set to be implemented on September 18, 2023, setting a precedent that could be repeated throughout the country. The state's highest court voted 5-2 in favor of overturning a previous ruling by a Kankakee County judge who ruled that the end of cash bail was unconstitutional. The decision, authored by Justice Mary Jane Thies, emphasized the importance of striking a balance between the rights of defendants and the rights of crime victims to ensure equitable treatment of all those awaiting trial in the justice system. The ruling was met with both praise and opposition. Illinois Attorney General K.W. Aim Raoul, whose office vigorously defended the end to cash bail, expressed satisfaction with the court's decision. He reiterated that the General Assembly holds the authority to replace cash bail with a system based on public safety and flight risk, not financial means. The court's decision today holds C as my office has consistently advocated C that the General Assembly had the authority to eliminate cash bail and replace it with a system in which people are detained pending trial only if they pose a threat to the public or are a flight risk, Raoul stated. And it rejects the plaintiff's argument that courts must retain the authority to set cash bail free of legislative irregulation, an argument that would have called into question decades of criminal justice reforms in our state. Someone's experience with the criminal justice system should not vary based on their income level. The SAFE-T Act, an ambitious reform aimed at addressing long-standing inequalities in the justice system, gained significant support from Cook County State's Attorney Kim Foxx. She hailed the ruling as a monumental milestone toward achieving equal justice for all in Cook County and Illinois, reaffirming her commitment to ensuring fairness, irrespective of an individual's background or financial standing. However, not everyone shares the enthusiasm for this momentous change. Justices David Overstreet and Lisa Holder White dissented from the majority, arguing that eliminating cash bail disregards the rights of crime victims enshrined in the state's Constitution. This disagreement highlights the ongoing debate surrounding the delicate balance between criminal justice reform and protecting the interests of those impacted by crime. The Illinois Fraternal Order of Police also expressed its disappointment in the court's decision, warning of potential consequences that could arise from releasing dangerous criminals back onto the streets. The organization criticized the ruling, claiming it solidifies Illinois' status as the state of lawlessness and disorder. Despite these differing perspectives, the Illinois Supreme Court's ruling marks a significant milestone in the ongoing fight for criminal justice reform. By eliminating cash bail, the state aims to break the cycle of poverty-driven incarceration, ensuring that individuals awaiting trial are not unduly penalized based on their financial circumstances. The decision is set to reshape the landscape of the Illinois justice system, inspiring other states to reconsider their own approaches to pretrial detention and bolstering the nationwide pursuit of a fairer and more just society. The elimination of cash bail has been a point of contention between Republicans and Democrats. Nationwide, Democrats have worked to eliminate the practice, saying it is unfair and could violate people's civil rights. Republicans have attempted to make it even more difficult to get out of jail while awaiting trial, claiming it will keep dangerous criminals off the streets. Forbes writer Maggie N. Germano N. says, "Cash bail is unfair, unjust, and it disproportionately hurts communities of color and poor communities." According to a report from 2020, about 500,000 people in jails haven't been convicted of a crime this represents. 75% of the total number of individuals in the jail system. At least 90% of these individuals remain incarcerated strictly because they can't afford bail. Many have argued that cash bail fuels a pervasive problem of structural racism in our criminal justice system. The pretrial population in the United States shows significant racial disparities, with Black and Hispanic individuals being disproportionately detained. Black and Hispanic Americans are more likely to experience police stops, encounter police violence during arrests. They are also more likely to struggle with poverty, making it difficult for them to raise funds for bail, as pretrial detention can throw a person's life into turmoil and make it impossible for them to continue earning a living. Poor detainees are more likely to plead guilty just to avoid the excessive time they will have to wait for trial. These racial disparities persist despite some efforts towards pretrial reform in various states, indicating an urgent need to address the issue of racial justice in the pretrial process. Despite these differing perspectives, the Illinois Supreme Court's ruling marks a significant milestone in the ongoing fight for criminal justice reform by eliminating cash bail. The state aims to break the cycle of poverty-driven incarceration, ensuring that individuals awaiting trial are not unduly penalized based on their financial circumstances. The decision is set to reshape the landscape of the Illinois justice system, potentially inspiring other states to reconsider their own approaches to pretrial detention and bolstering the nationwide pursuit of a fairer and more just society.